Hi, welcome back. I'm Terry Wilson with Wilson Realty. Just wanted to take a few minutes to talk with you about the offer to purchase and contract that we use in North Carolina. It's called the offer to purchase and contract Form 2T. Not that you need to know that, but that's what we refer to it as. So I wanted to just kind of take you through a couple of essential elements of that contract that you will want to be familiar with. First of all, whether you are a seller or a buyer, the agent that is working with you will provide to you a sample copy of the offer to purchase a contract Form 2T. I strongly encourage you to read that once you get a listing or you are a buyer and you want to work with a buyer's agent. I strongly encourage you to read that offer to purchase a contract sooner rather than later. Because what you don't want to do is be in a position where you've never read the offer to purchase and contract until you actually either are presenting an offer or you're a seller and you are receiving an offer. And that's the first time that you've reviewed that contract. There are a lot of legal terms in the contract. There are a lot of obligations, rights, and responsibilities in our offer to purchase and contract. So it's very important that you be familiar with that contract before you actually get a live offer. So when it comes to the offer to purchase and contract, of course, all parties have to sign for it to ripen from an offer to a contract. All parties have to sign. And that signature, as we've discussed before, has to be communicated. On the offer to purchase and contract, you'll want to indicate all of the sellers of the property, all the names of the sellers, all the names of the buyers. And also, if the buyer wants to receive personal property from the sale, in other words, the buyer says to the seller, I would like to buy your home, but in addition, I also want the washer, dryer, and refrigerator, then the buyer should make sure to put that under the personal property that is to remain on the property. And I encourage you, the buyer, to be very specific as to what you're referring to. So you would not want to just simply put down there refrigerator. What you want to put down there is the make and model of that refrigerator so that it is clear as to which refrigerator you are expecting to get when you purchase the home. If it is on the offer to purchase and contract from the seller's perspective and the seller agrees to, by their signature, the seller agrees to convey the washer and dryer and refrigerator because that's what's on the offer to purchase and contract, then they have that obligation to convey the washer, dryer, and refrigerator. But again, you want to be specific because if all you put down there is refrigerator, you may not get the refrigerator that you want because the contract is going to be very specific as far as what does the term refrigerator mean. It just means a generic refrigerator. So you want to be clear and specific what you're referring to. So that's personal property that is to remain. And again, it has to be in the offer to purchase and contract. Otherwise, the seller is under no obligation to convey that personal property to the buyer. If it is not, as we lovingly refer to, if it is not glued, screwed, nailed, stapled, or otherwise permanently attached to the property, then by default, it is considered personal property. And unless it's included on the offer to purchase and contract, then the seller has the right to remove that item and take it with them. If there's ever any confusion as to whether something is or is not personal property, it is best to make sure that all parties clarify whether it really is remaining or whether it's going. Once a seller takes something that's personal property and affixes it to the property, in other words, they buy a ceiling fan and then they install the ceiling fan into the ceiling, well, now it's bolted. And because it's bolted, it is part of the real property that is conveying. And therefore, the buyer does not have to indicate that the ceiling fan is to remain because it is bolted to the home and therefore is part of the real property. And as such, the buyer has the right to expect the ceiling fan to be there when they purchase the home. Can the seller take the ceiling fan with them? Absolutely. As long as they have the buyer's permission to remove the ceiling fan and to make the proper repairs. In other words, If there's a hole, fix the hole. If painting needs to be done, to paint. In other words, to properly repair any damage left over by removing the item. A classic example is televisions that are mounted on the wall. The fixture, the bracket that is used to mount the television, is physically bolted into the wall. The seller certainly has the right to take that item with them, but they must accept it in the contract. They must notify the buyer that they want to remove this fixture from the house. And if, assuming the buyer agrees that they can remove that fixture from the house, the seller is responsible for making the proper repairs, patching the holes that are left behind by the bolts that were used, and most likely repainting at least that wall to properly repair that space. So again, the seller can take items that have been affixed to the property should they choose to, but they need to have the buyer's permission. Or what might be smart for the seller to do is to remove those items before they put the home on the market. That way, the buyer doesn't even know that they're there. So if the seller, for example, has a lovely chandelier that maybe has been passed down from generation to generation, and they want to take that item with them, then the smart thing to do would be to remove that chandelier before the showings start, so there doesn't become this argument of the buyer saying, but I want the chandelier, and the seller saying, but I don't want to give you the chandelier. This way, the buyer doesn't know the chandelier even existed. You would want to obviously put something back that's nice to help show your home. So just be aware that things that are attached in some way or somehow attached to the property, those are considered real property items, and the buyer has a right to expect them to be there. From the buyer's perspective, anything that is not attached permanently, such as a washer, dryer, and refrigerator, those are considered personal property items. The buyer wants to be clear and specific as to what items are to remain. And again, the seller has to agree to it. And if the seller does agree to it, then it becomes part of the contract, and the seller has an obligation to convey those items to the buyer. Now, it's important to understand that it's not uncommon for sellers via the listing agent to advertise that the washer and dryer or refrigerator or some other item will be included in the sale. That's an advertisement, essentially. There's no obligation for the seller to leave the refrigerator, even if they advertised they were going to leave the refrigerator, again, unless it is a built-in fixtured refrigerator, like a Sub-Zero that has been built in. But if it's a freestanding refrigerator, that is considered personal property. So even if the seller is advertising that they will convey the refrigerator to the buyer, the seller's under no obligation to make that conveyance to the buyer if the buyer did not request it in the offer to purchase and contract Form 2T. It is the only document that matters because it is the agreement between the buyer and the seller as to what is going to happen with the conveyance of the property. So you want to make sure that even if the seller is advertising washer, dryer, and refrigerator, that it is included in the offer to purchase and contract. Once you go under contract, once the two parties go under contract, the buyer will be given what's called a due diligence period of time. It's a negotiable period of time, but it ends at 5 p.m. Time is of the essence. So if the buyer and the seller agree that the buyer will get a 2-week period for the due diligence period, or they'll get a month, 30 days due diligence period, at the end of the 30 days at 5 p.m., time is of the essence, which means contractually you cannot miss it by a second. The buyer has to decide whether they want to stay in the contract during that period of time. Because once the window closes at 5 p.m. on the last day, now if the buyer wants to walk away, they're technically in breach of contract. So the buyer is paying for, or maybe getting that due diligence period for free. They pay what's called a due diligence fee. Now, it may be that they negotiate that they want 14-day due diligence period for no fee. And if the seller agrees to that, that's fine. They have their 14 days. And during those 14 days, the buyer can walk away for any reason or no reason at all. even if the seller made all of the repairs, even if the seller made all of the improvements that the buyer asked for, even if the seller spent $20,000 on improvements and repairs. During the due diligence period of time, if the buyer chooses to walk away, they have paid for the right to do that, or even if it's free, the seller has agreed to give them that time to do that. And during that period of time, they can walk away for any reason or no reason at all. Should the buyer pay a due diligence fee to the seller for that period of time, then the check is made payable to the seller. The seller can do whatever they want with the money. Should the buyer go all the way to closing and settle up and actually have the house transfer, the due diligence fee is credited to the buyer on the closing disclosure. It is a credit given to the buyer at settlement to show that they basically have prepaid a portion for the house. But again, the seller can do whatever they want with that due diligence fee. They can buy a plasma TV if they want to. I would suggest as a seller, however, that instead of spending that money, that you put it into a savings account and hold on to it. Because there could be certain situations that you would be required to give the buyer their due diligence fee back. One of the reasons you would have to do that is if there was a breach in contract caused by you, the seller. And there's lots of reasons that could happen. So I don't suggest, although you are allowed to spend the money any way you want, I would suggest you just simply put it into a savings account and hold on to it. That way, if for some reason the buyer justifies getting their due diligence fee back, then you've got the money, it's there, give it back to the buyer, end of story. But again, the buyer gets a due diligence period of time. That length of time is negotiable between the buyer and the seller. And your agent will explain to you, the buyer, as far as depending on where you are in the process of purchasing, how long that due diligence period should be. The listing agent will advise you, the seller, as to what the implications are of the due diligence period and how long it should be, et cetera. And it's a negotiable period of time between the buyer and the seller. So too is the due diligence fee. There may be a situation where the seller wants more and shorter time. It may be that the buyer wants a longer time for less money. Somewhere in there, they will find their happy place. And when they go under contract, the due diligence fee is to be submitted to the seller the date they go under contract. The date they sign, sealed, delivered. Then the due diligence fee check needs to be delivered to the seller. Typically, it's delivered to the listing agent who will then pass it on to the seller. I strongly encourage both buyer and seller that if in fact the buyer is not in town, if they want to mail the check, I would be very careful about how you mail that. You probably are going to want to have signature receipt mailing. I would not simply put a first class stamp on it and mail it. You want proof that it has been received. So that's the due diligence period. It is a time in which the buyer must do all of their due diligence, all of their homework to decide whether they want to buy the home, which means they have to have their loan in place, which means they have to have their inspections done. It means that they should have their appraisal done. Any other inspections other than mechanical, structural, maybe well septic, maybe structural. Maybe they want to have the property surveyed to see where the boundaries are. All of those things need to be done during the due diligence period of time. And the seller, per the terms of the contract, agrees to give the buyer reasonable access to the property so that the buyer can do proper inspections. If you, the seller, did not give the buyer reasonable access to the property, then that could put you, the seller, in breach of contract, where you may have to give the due diligence fee back because you didn't allow the buyer to do their due diligence. In addition to that, the seller agrees that if the utilities exist on the property, such as water, gas, electric, that it is the seller that agrees that those items, those utilities, will be working on behalf of the buyer so the buyer can do their inspections properly. What this means to you, the seller, is that if you have winterized the home, you're no longer living there, it's a vacant property. If you go under contract with a buyer, then you, the seller, agree that you will have the utilities turned back on so that the buyer can do their proper inspections during the due diligence period of time. Buyers, your responsibility is to make sure that you make all of your buying decisions during the due diligence period of time. And if during that period of time you decide you do not want to buy the home, you, through the due diligence fee, assuming you did pay a due diligence fee, you have paid for the right to walk away from the contract. And should you walk away from the contract during the due diligence period of time, and again, a buyer can walk away for any reason or no reason at all, as long as it's during the due diligence period. And if they do walk away, the seller keeps the due diligence fee as compensation for the buyer's right to walk away, but the buyer gets their earnest money deposit back. Earnest money deposit is held in a trust account, either at a real estate company or an attorney. It's held in a trust account. It's another term for earnest money is good faith money. It's not required. You don't have to have earnest money. Just like you don't have to have a due diligence fee, you don't have to have earnest money. But if there is earnest money paid, then those monies will sit into a trust account. If the buyer goes all the way to settlement, then just like the due diligence fee was credited to the buyer at settlement, so too will the earnest money deposit. That will be credited to the buyer as part of the basically the down payment that they gave on the property. Should the buyer walk away during the due diligence period, they get their earnest money back, but they do not get their due diligence fee back because they bought the right to walk away. If, however, it is after 5 p.m., time is of the essence on the last day of the due diligence period. If after 5 p.m., you, the buyer, decide to walk away, now at that point, you are in breach of contract, unless the seller forced you to walk away. But if you walk away because you simply don't want to buy the home, now you are technically in breach of contract. And if you walk away after the due diligence period window closes at 5 p.m., regardless of the reason, it could be, I didn't get my appraisal in time. It's after 5 p.m. and I finally got my appraisal. Or I didn't get the inspection report. Or I sent my request into the seller for repairs, but I never heard back from them. So I don't know whether they were going to make the repairs or not. And now it's after 5 p.m., only to be told now that they won't make the repairs. It doesn't matter what the reason is. If you leave after 5 p.m. and you leave not because the seller breached contract or the seller forced you out of the contract, but you just simply walked away for any reason, once that 5 p.m. window closes, now you are in breach of contract, and now the seller has the right to keep your earnest money deposit. The seller will have kept your due diligence fee because that's the fee you paid them for the right to have that due diligence period. But you didn't use it. You stayed in the contract. 5 p.m. rolled around. Only then you want to back out. Now the seller is going to keep your earnest money deposit. So it's very important that both parties understand the due diligence fee, what it pays for, who gets it, when they can keep it, when they can't, and the earnest money deposit. That you will get it back if you walk away from the contract during the due diligence period, but if you, the buyer, walk away after the due diligence period, you do not get it back unless you can prove somehow that the seller was in breach of contract. So that's the due diligence period of time. And again, just as a reminder, it is a time is of the essence. It's very critical that you get everything done during that period of time, including negotiation of repairs. The seller, unless you, the buyer, insist, the seller does not actually have to make the repairs during the due diligence period. And I don't know that I would force them to, because you don't want to make the seller hurry and make shoddy repairs just so they can get them done. But you, the buyer, want to make sure that the seller agrees in writing to make those repairs. So that's the due diligence period of time. Assuming that everything is going smoothly and the buyer is in the contract, then the next major date is called the settlement date. Settlement is where the parties go to an attorney's office and sign all of the appropriate paperwork. Settlement is not closing. Settlement is not closing. Settlement is where we go to the attorney's office and we go ahead and sign all of the paperwork that needs to be signed. And there's lots of paperwork, particularly for the buyer. Our offer to purchase contract states that settlement can be delayed for up to 14 days by either party. As long as they are trying to close, they don't have to give a reason. So either party can delay closing up to 14 calendar days. Holidays aren't considered. If 14 days from now is Christmas Day or some other major holiday, that's 14 days. So it can be delayed 3 days, it could be delayed 2 days, it could be delayed 9 days, it could be delayed up to 14 days. If 14 days come and go and the delaying party still cannot close or settle, then after the 14th day, the non-delaying party, the one that did not need the delay, can decide whether they want to extend, allow this to extend further, or do they want to get out of the contract and move on? So it's important to remember that either party can delay closing settlement technically up to 14 days. Up to 14 days. I don't encourage it, but there are times when that can happen. There's a myriad of reasons why closing may need to be delayed. And they can delay it for up to 14 days at no penalty. Once all the paperwork is signed, then the attorney will record at the Register of Deeds the transference of the deed from the seller to the buyer. And that in North Carolina is technically closing. Deed recordation, proving to the world that the buyer now owns the house, is technically closing. And it's critical that you understand that until the deed has been recorded, you, the buyer, do not yet own the house. You, the seller, still own the house. Why is that important? Well, what if you have settlement on the morning, on a Friday morning, and before the deed is recorded, the house burns down? That is on the seller. It is the seller's obligation because the seller still owns the house. With that said, there's a couple of things that I want to mention when it comes to closing. One, as a seller, don't cancel your insurance until the deed has been recorded, and even then hold on to it for a couple of more days. It won't cost you any more money. They'll back your payments that you made back up to the settlement date. But you want to make sure that you keep your homeowner's insurance policy in place just in case there is a problem. Two, oftentimes buyers will expect to get the keys at the attorney's office. They may not. And it's very important to remember that until the deed's recorded, the seller still technically owns the house. So it may be that the seller says, I'm not going to give you the keys until the deed's recorded. And there's nothing wrong with that, as long as all the parties are on the same page. So I encourage you as a buyer and as a seller, before you get too far into the transaction, before the rental vans are rented to move all the stuff, before the hotel rooms are scheduled because you're coming in from out of town and you're going to have to stay in a hotel. Before all of that happens, have a discussion between each other as to when the keys will be transferred, and make sure that the agents are fully aware of that so that everyone can plan accordingly. The last thing and the hardest thing for a buyer is to go to settlement only then to find out they're not going to get the keys until the deed is recorded. One other thing, it's called the Good Funds Settlement Act, and it's a law in North Carolina. And the Good Funds Settlement Act says that no funds can be dispersed by the attorney. Money's dispersed to the seller for the sale of for the sale proceeds, or any monies to the agents, their commissions. No monies can be released from the attorney until the deed has been recorded. So the way the Good Funds Settlement Act works is any monies coming into the attorney must be considered good. Now, under the Good Funds Settlement Act, You can, a check, a personal check written up to $5,000, although most attorneys cap it at 500. A personal check up to $5,000 is considered good by the Good Fund Settlement Act, and therefore you do not have to wait for that check to clear. Amounts above either what the attorney has established or the law, 5,000, amounts above that, you cannot proceed forward until that check is cleared, and therefore the funds are good. Once those funds are considered good, then the attorney can record the deed. And then once the deed is recorded, proving to the world that the buyer now owns the home, then the funds can be released to the seller. So the seller can then take those monies and do what they're going to do next, whatever their next chapter is. So that's a little introduction on the offer to purchase and contract, some major highlights of it that I've seen in the past that can trip folks up. So just wanted to make sure that you were somewhat familiar with those things. And again, I strongly encourage you, read that offer to purchase and contract. Read it. When you sign that offer to purchase a contract, you are obligating yourself to those things, even if you don't know what you signed. You are obligating yourself to those things. So anyway, just wanted to share that with you. I wish you the best of luck in your home purchase and in your home sales. And thank you so much for choosing Wilson Realty. It truly means the world to us, and we are very honored to help you all. Take care. Bye-bye.